So Katy Perry has managed to overturn a $2.8 million judgment against her for copyright infringement against Flame the rapper. And in other news that you probably also don't care about, I successfully balanced 3 golf balls on top of each other. Viva Frei, Montreal litigator turned YouTuber, and I have about 30 minutes of silence while the family is outside getting their daily dose of sunlight. For those of you who don't know, a Christian rapper named Flame sued Katy Perry for copyright infringement as relates to use of a portion of his song called Joyful Noises in her song Dark Horse. The dispute went to trial, a 2-week trial by jury, and the jury found in favor of Flame the rapper and ordered Katy Perry to pay him $2.8 million for copyright infringement. Following the jury's verdict, Katy Perry filed something that is referred to as a renewed motion for judgment as a matter of law or motion for a new trial. That motion was presented to the same judge who was the judge in the trial by jury, and that judge found in favor of Katy Perry and basically overturned the trial of the verdict. What the heck am I talking about? The verdict of the jury. But we're getting ahead of ourselves. Now, this is procedurally very complicated, and the judgment is 32 pages, so I'm going to do my best to simplify and shorten. Defendant's renewed motion for judgment as a matter of law, or alternatively for a new trial. The first question is, what exactly is a motion for judgment as a matter of law? A motion asking the court to enter judgment as a matter of law. This motion is made before a case is submitted to the jury and argues that no reasonable jury could find for the opposing party. In federal court, this motion may be renewed after an adverse jury finding. So what this motion says in a nutshell is that this matter does not even need to go to a jury who are finders of fact, because as a pure matter of law, it is baseless. However, after an adverse jury verdict, a renewed motion for judgment as a matter of law can be presented to the judge to basically say the jury got it all wrong. In fact, set it aside because as a pure matter of law, it should never have gone that way. And that is exactly where we are at with this Flame the Rapper versus Katy Perry lawsuit. Katy Perry is saying, okay, we got an adverse verdict by jury, set it aside. We are filing a renewed motion for judgment as a pure matter of law because as a pure matter of law, which the judge alone is able to adjudicate on, this lawsuit should have been dismissed. I hope that's clear. This copyright infringement action concerns the allegation that an 8-note ostinato from defendant's song Dark Horse infringes upon the plaintiff's copyright in the musical composition of the 8-note ostinato in their song Joyful Noise. Following a jury trial, the jury found for the plaintiffs, awarded damages, and the court entered judgment. Now before the court are the defendant's renewed motions for judgment as a matter of law, or in the alternative for a new trial, as well as plaintiff's motion for prejudgment interest on its damages award. Now let's skip right to the essential here. What on earth is an ostinato? Now first of all, in Quebec we pronounce it ostinato, and my Quebecers are going to get that joke. But what is an ostinato? Hey Siri, what is an ostinato?
In music, an ostinato is a motif or a phrase that persistently repeats in the same musical voice, frequently in the same pitch.
Okay.
Shall I continue?
No, thank you. That was actually very good. Thank you for contributing to the video.
In music, an ostinato is a motif or a phrase that...
So that's what an ostinato is, and if you've heard Dark Horse, you know exactly what the ostinato is. I'm not going to sing it, because if I do sing it, this video will get claimed. But it goes something like this. Something like that, and now you know exactly what I'm talking about. We're going to skip the entire section on plaintiff's motion for prejudgment interest, just knowing the way the judge rendered her verdict. But essentially, plaintiff's motion for prejudgment interest is a motion claiming interest on the amount of the award from the date the lawsuit was filed to the date the judgment was rendered. When you're dealing with a sum of $2.8 million and proceedings that have been going on for a couple of years, that prejudgment interest can be substantial. Knowing that the judge granted Katy Perry's renewed motion for a judgment as a matter of law and or ordered a new trial subsidiarily, the question of prejudgment interest becomes academic. Judgment as a matter of law is appropriate when a party has been fully heard on an issue during a jury trial and the court finds that a reasonable jury would not have a legally sufficient evidentiary basis to find for the party on that issue. So basically, after the trial, after the jury has heard all the evidence, after the jury has rendered their judgment, a judge comes in and says that no reasonable jury could have found what the jury in fact found.
Once again, things that could have been brought to my attention yesterday!
We have already discussed the concept of judgment as a matter of law, so let's just get into the substance of the judgment itself. To prove copyright infringement, a plaintiff must establish 1. Ownership of a valid copyright, and 2. Copying of constituent elements of the work that are original. The sole issue at trial concerned the second element, whether defendant's ostinato 2 in Dark Horse infringed upon plaintiff's ostinato in Joyful Noise by copying constituent elements of plaintiff's ostinato that are original. Substantial similarity is determined by a 2-part test of extrinsic similarity and intrinsic similarity, and I'm going to have to finish this vlog in the car.
No, you can do it now. Ethan's going back outside.
Okay. A collection of otherwise unprotected elements may be found eligible for copyright protection under the extrinsic test, but only if those elements are numerous enough and their selection and arrangement original enough that their combination constitutes an original work of authorship. So just to simplify this, you have the extrinsic test and the intrinsic test. The extrinsic test requires the plaintiff to provide concrete evidence that the works are similar. And in that test, you have to, on the one hand, identify the protected elements of the work, and on the other hand, show that they are similar to the infringing work. Only once the plaintiff has satisfied these two elements does the matter then get submitted to the intrinsic test, which is for the fact finder to determine whether a reasonable listener would determine that there is substantial similarity between the works. And even then, even if the plaintiff does in fact prove substantial similarity, the plaintiff need nonetheless prove access to the protected work. Proof of access requires an opportunity to view or copy plaintiff's work. To prove access, a plaintiff must show a reasonable possibility, not merely a bare possibility, that an alleged infringer had the chance to view the protected work. Where there is no direct evidence of access, circumstantial evidence can be used to prove access either by establishing a chain of events linking the plaintiff's work and the defendant's access, or showing that the plaintiff's work has been widely disseminated. And so here basically you can have actual matter-of-fact access, like the defendant got into the computer of the plaintiff, or you can have presumed access in that the plaintiff's song was playing on the radio all over the place, and so the defendant had to have heard it even if subconsciously. And then we get into the meat of the analysis of the extrinsic test. Although there is generally a low bar for originality in copyright, given the limited number of notes and chords available to composers, and because common themes frequently reappear in various compositions, many, if not most, of the elements that appear in popular music are not individually protectable. Musical elements that are common or trite, such as the use of a long, short, long rhythm, chord progression, certain tempos, a recurring vocal phrase, repeating hook phrases, the alternating emphasis of strong and weak beats, syncopation, the use of tritones, or the use of basic musical devices in different manners, are accordingly not protectable. And so now you can anticipate that the entire argument is going to be breaking down this ostinato to see whether or not the individual elements themselves are protectable. In their opposition papers, plaintiff claimed that these 5 or 6 elements are actually 9 separate elements. 1. A melody built in the minor mode. 2. A phrase length of 8 notes. 3. A pitch sequence beginning with 3-3-3-3-2-2. 4. A similar resolution to both phrases. 5. A rhythm of 8 notes. 6. A square and even rhythm. 7. The structural use of the phrase as an ostinato. 8. The timbre of the instrumentation. And 9. The notably empty and sparse texture of the compositions. Appreciate now that ostinato, and I'm actually now doing it by accident, the ostinato. That's not how it goes, but you know what I'm saying? They are breaking down that 8-note ostinato to determine whether or not each individual element is protectable. Plaintiff is saying that it actually is composed of 9 protectable elements which make it unique, and the judge, sure as sugar, is going to come in and say, no, each and every one of those elements is not protectable, therefore the entire work is not protectable. The court agrees that the uncontroverted evidence points to only one conclusion, that none of these individual elements are independently protectable. It is plaintiff's burden to establish the protected elements of their allegedly infringed work. Dr. Decker is actually the musicologist, the expert witness that testified on behalf of plaintiffs. Dr. Decker did not provide testimony that each of the elements he identified are individually original. To the contrary, he testified that no one single element caused him to determine that the works contained protected features that were substantially similar. Any single one of those elements would not have been enough, he conceded. It's the combination of them that supported his conclusion. Further, Dr. Decker conceded in substance that several of the allegedly original individual elements of plaintiff's ostinato are not original. 1. With respect to the phrase length of 8 notes, Dr. Decker testified that it is, quote, characteristic for a phrase like this ostinato to last for 8 beats. 2. With respect to the beginning pitch sequence of 3-3-3-3-2-2, Dr. Decker testified that a repeating scale degree of 3 that later resolves is a technique used for building up tension that wants to be released, and that when such tension is released in a song with strong beat like joyful noise, it is released. 3. With respect to the way the joyful noise ostinato resolves from 3 to 2 to 1, Dr. Decker testified that, quote, scale degrees have tendencies in popular music such that, to make a pleasant consonant sound, 3 wants to go down to 2, and 2 desperately wants to go to 1 because 1 is our home note, which indicates that the way the ostinato resolves is not so much original as it is necessary. Dr. Decker testified that ostinatos are commonly used musical devices in countless musical compositions. And then the judge concludes as follows: in fact, the 9 individual elements that plaintiff identify in their opposition are precisely the kinds of commonplace elements that courts have routinely denied copyright protection, at least standing alone, as a matter of law. And here is where I have a big problem with the judgment. The courts have denied protection to these elements at least standing alone, and that is the critical distinction, because in this case they are not standing alone. In this particular case, there are admittedly 9 elements of this ostinato combined into one. They are not standalone elements. In my humble opinion, the analysis that the judge is engaging in right now effectively breaks down the ostinato in the same way it would be breaking down a novel into letters. Following the same rationale, the judge could conclude that no novel could be copyrighted because each individual standalone element, that being the letters with which each word is composed, are not protectable, so therefore the composition is not protectable. As far as I'm concerned, the 9 elements elements that create the impugned ostinato are basically like the letters that create the poem. And I think the judge has broken this down to such an artificial degree that it's sort of like looking at a forest and saying, there is no forest there, all I see are a bunch of trees. Plaintiffs may still prove infringement of their ostinato if they can demonstrate that it is comprised of a protectable combination of otherwise unprotected elements. Those elements must be numerous enough and their selection and arrangement original enough to warrant protection as an original work of authorship. In considering this issue, the court is guided by relatively little precedent, beginning with perhaps the most notable case that found a protectable combination of otherwise unprotected musical elements. In Three Boys, the Ninth Circuit affirmed a finding of copyright protection based on the combination of 5 otherwise unprotectable elements: the title hook phrase, including the lyric rhythm and pitch, the shifted cadence, the instrumental figures, the verse-chorus relationship, and the fade ending. How on earth does that reasoning not apply to this ostinato? It is undisputed in this case, even viewing the evidence in the light most favorable to plaintiffs, that the signature elements of the 8-note ostinato in Joyful Noise, the 3-3-3-3-2-2 pitch sequence, the resolution of that sequence with a 3-2-1-5 sequence, the even rhythm without syncopation, and its development across a sparse texture, is not a particularly unique or rare combination, even in its deployment as an ostinato. Prior compositions, including prior works composed by the parties, as well as what all agree is a separate non-infringing ostinato in Dark Horse, all contain similar elements. Sure, they all contain similar elements in the same way sheet music all contains similar elements in the note, but they all sound very different, which is what makes them original. There is a very good reason why we can distinguish between these ostinatos, and it's because they don't sound the same, which is what makes them original. The other elements present in plaintiff's 8-note ostinato also do not bring the combination within the ambit of the copyright law's protection. The placement of the ostinato within the composition's verses does not make it so exceptionally original as to warrant protection. That conclusion to me does not seem to be a matter of law. That seems to be a matter of opinion, and a jury that heard this for 2 weeks came to a different opinion. Because the sole musical phrase that plaintiffs claim infringement upon is not protectable expression, the extrinsic test is not satisfied, and plaintiffs' infringement claim, even with the evidence construed in plaintiffs' favor, fails as a matter of law. I respectfully disagree, and I predict that if this goes to appeal, this judgment will get overturned. And then just to hammer a few more nails in plaintiff's coffin, the judge gets into the substantial similarity argument. Even if the 8-note ostinato were protected expression as a combination, defendants would still be entitled to judgment as a matter of law, since the evidence submitted at trial does not support a legal conclusion that the two ostinatos are objectively substantially similar. Except that is not what the jury found after a 2-week trial and after having heard all of the evidence. Reading this judgment, it just seems to me that the judge has effectively come in and usurped the entire power of the jury. The judge clearly disagrees with the jury, but the jury came to the very opposite conclusion after 2 weeks of trial and after having heard all of the evidence. Defendants also moved for judgment as a matter of law on substantial similarity pursuant to the intrinsic test. The intrinsic test is subjective and asks whether the ordinary reasonable person would find the total concept and feel of Joyful Noise and Dark Horse to be substantially similar. Although some district courts have determined that the intrinsic test can be resolved as a matter of law in music copyright infringement actions where no reasonable person could confuse the subject composition's overall concept and feel, the court declines to do so here. Even though the court concludes that plaintiff's ostinato is neither protected nor virtually identical to the alleged infringing ostinato in Dark Horse, a reasonable jury could nonetheless conclude that the concept and feel of the two ostinatos in this case are intrinsically similar. Alright, we have done enough of the nitty-gritty analysis. We're going to get to the conclusions of the judgment where the judge protects herself, as we say, but before we do that, if you like my videos and you like my content, please be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section below to feed the algorithm. Skipping to the CYA judge's conclusions, and you'll see what I mean when I say that. Because the court concludes that defendants are entitled to judgment as a matter of law on plaintiff's copyright infringement claim pursuant to the extrinsic test, defendant's motion for a new trial is denied as moot. However, had the court not granted defendant's judgment as a matter of law on liability, the court would have exercised its discretion to order a new trial on damages unless plaintiffs accepted a remittitor, the jury's damage award in this case, which disregarded powerful testimony that it was Katy Perry's star, power, and Capitol Records marketing efforts, not plaintiff's ostinato, that generated Dark Horse commercial success, seems clearly against the weight of the evidence presented at trial, even if otherwise based on substantial evidence offered by the plaintiffs. A remittitor is a ruling by a judge lowering the amount of the damages awarded by a jury in a civil trial. And here, yet again, we can basically see the judge saying, I strongly disagree with the jury's findings, and had they not agreed to lower the amount, I would have ordered a new trial. The court concludes as follows. 1. Defendant's motion for judgment as a matter of law is granted, and the jury's verdicts as to liability and damages are vacated because plaintiffs fail to satisfy the extrinsic test. 2. Defendant's motion for a new trial is denied as moot. 3. Plaintiff's motion for prejudgment interest is denied as moot, as are any related evidentiary objections. In the event that the Court of Appeals were to find that judgment as a matter of law on the extrinsic test is not appropriate in this case, the court conditionally grants a new trial because, for the same reasons set forth above, the jury's findings on the extrinsic test and damages are against the the clear weight of the evidence. When I said that this was a CYA judgment, what the judge is effectively saying is, I know this is going to go to appeal to the Ninth Circuit, I believe. If and when it gets there, even if my judgment is overturned on the merits, I would have ordered a new trial anyhow. We'll see where this goes, but my prediction is that if this does indeed go to appeal, this entire judgment is being overturned and the jury's verdict is going to be reinstated. But my more realistic prediction is that this is going to settle before it goes to appeal, because this can probably be settled for $500,000 to $1 million, which would be nothing for Katy Perry, which would probably be a lot for Flame the rapper, and they both have too much to lose by leaving this in the hands of the Court of Appeal, having seen now that this can go one way with the jury and the other way with the judge. That is my prediction. We'll see where it goes, and with everything else that is going on in the world right now, deep breaths, be calm, have faith, and take care of yourselves. Now you know your vlog. Peace out.